An informative presentation video on the McCollum v. Board of Education law case of 1948 by Michael Chiango for American Education College class to be presented November 2nd, 2020. Case Summary. McCollum v. Board of Education was a landmark Supreme Court case that dealt with the First and 14th Amendments to the Constitution in deciding whether or not a public school system was legally able to hold sectarian religious classes during school hours on school property. The ruling found that the Illinois Public School Board had in fact violated the First Amendment's Establishment of Religion Clause by introducing religious instruction in tax-subsidized schools, and the program was ended. Background. Gary, Indiana, in 1914, was the first U.S. district that established a release-time religious program in public schools. Decades later, in Champaign, Illinois, 1940, members of various Protestant, Catholic, and Jewish faiths formed an association known as the Champaign Council on Religious Education, the goal of which was to further the spread of religious values to teach children who did not regularly attend church or a private religious school. This association obtained permission from the Champaign Board of Education to offer voluntary religious education classes in public schools from 4th to 9th grade. 30 to 45-minute classes were to be held each week by qualified religious instructors during school hours, with separate instructions given for Protestant, Catholic, and Jewish students. Parents needed to give their kids permission to attend, and the schools passed out cards that would need to be brought back to the school with a parent's signature and 25 cents to pay for the extra costs of financing the program. It is important to remember that at the time when all this was taking place, the world was fully engulfed in the Second World War, and it was a time when every American was expected to unite in order to combat dangerous foreign powers. Not being religious was seen as synonymous with not being patriotic. Despite the fact that Nazi Germany and Italy under Mussolini were overwhelmingly Christian, people who were not religious in the United States were often called fascist during the wartime hysteria, and after the war, a wave of anti-communist sentiment swept over the continent, and atheism became synonymous with godless communism and the Soviet Union. Anything that seemed at least somewhat radical or different during this extremely conformist period in American history was seen as un-American and alien. Enter Vashti McCollum, who self-described herself as a follower of rationalism, including atheism. In the fall of 1944, Vashti had her son James, Terry McCollum, nicknamed Jim, enrolled in the Champaign Public School District at Dr. Howard Elementary School. He became the only one in the 5th grade not taking the voluntary religion course, and was removed from the classroom and made to sit in the principal's office or at a desk out by the hall. Vashti complained to the school district that she did not want to have her son enrolled in religious classes, and that he was ostracized and bullied by other students for not attending them. She requested school officials to stop offering the religious classes in public school, as she claimed they were unconstitutional, and after her complaints were unanswered, she ended up suing the school board in July of 1945. Significant individuals involved. Vashti McCollum, born in 1912 in Lyons, New York. She was the second daughter of Arthur Gifford Cromwell and Ruth Claus Cromwell, sister of Helen Cromwell, mother of her 3 sons, James Terry McCollum, Daniel McCollum, and Errol McCollum, wife of John McCollum, and plaintiff of the Supreme Court case. She had been baptized and raised in the Lutheran Church, but religion meant very little to her for the most part, and she lived her life without religious convictions. She did not have disdain for religion, but wanted her children to be raised without religious influences. She was a tough and hard-working, educated woman who took on a large chunk of the responsibility for filing her suit herself. James Terry, or Jim McCollum, the son of Vashti and John McCollum. Originally, Jim desired to attend the religious education classes because he wanted to fit in with the other kids, and he was put under a lot of pressure from his teacher to join. And so he was allowed by his mother to attend the program in the second semester of the 5th grade. However, Vashti soon realized that he was not merely learning about religious culture and history, but instead the classes were meant to indoctrinate kids with religious dogma. After that realization, his mother pulled him out of the program. The Dr. Howard School was a fairly hostile environment towards him, and whereas bullying was not usually a common occurrence at the school, Jim got into several fights and beatings from other students that appeared to be targeted due to religious prejudice. Arthur Cromwell, the father of Vashti McCollum, who by late adulthood founded the Rochester, New York Society of Freethinkers after years of religious academic study. Despite once belonging to the Lutheran Church, he became staunchly anti-religious later in his life. His thoughts on religion can best be summed up by this quote from his pamphlet, Rationalism versus Religious Education in Public Schools. The Bible contains so much that is bad, so little that is good, and nothing that is true, that it seems impossible that anyone who has read or studied it would recommend it as fit for youth to read, much less as moral inspiration. John Pappy McCollum, the husband of Vashti McCollum. Like Vashti, he also lacked any religious convictions, and that similarity between the two was part of what drew them to each other in the first place. He was raised in the Bible Belt and was exposed to talk of hell and damnation Sunday after Sunday, and was in full agreement with Vashti that he did not want their children to have anything to do with religion. Landon Chapman, lawyer hired by Vashti McCollum to aid her case against the circuit court in Champaign. He used extremely aggressive questioning for the leaders of Champaign's religious community in the trial about their personal faith. He had a flamboyant, sensational style that grabbed headlines for the circuit court trial, but not necessarily in a positive way. John Franklin, the attorney hired by the Champaign School Board to defend the allowance of religious education held in public schools. He viewed Vashti McCollum's efforts in the trial as sinister and largely saw the trial as an attack on religion by militant atheism. Frank B. Leonard, one of the 3 judges for the Illinois 6th Judicial Circuit, who previously had been a lawyer for the School Board of Champaign and was one of John Franklin's former partners. Philip Shugg, Unitarian minister who became one of Vashti McCollum's closest allies in the case. He was an extremely unorthodox religious leader who claimed that he did not believe in a literal God, and he did not believe in a literal Bible account, but instead believed in the God of nature, and viewed the Bible simply as a collection of stories for teaching moral lessons. Walter Dodd, a very professional constitutional lawyer who was semi-retired when Vashti McCollum hired him to take up her fight against religious education on public school grounds. He was much more of an intellectual than a performer who was interested in arguing the legal aspects of the McCollum v. Board of Education court case, and was very effective at doing so. Circuit Court Process and Ruling. With 3 boys to feed, and the family living mostly on John Pappy's modest university salary, Vashti McCollum could not afford a lawyer, but she did get in contact with the Chicago Action Council, or CAC, a group also concerned about religion being taught in public schools. The CAC promised to pay the legal bills for Vashti's suit. On June 11, 1945, with the help of Landon Chapman, Vashti filed her lawsuit to stop the teaching of religious content in the Champaign public school system. There was an immediate backlash, and the story of Vashti and her atheist family trying to remove religion from public schools was all over the local news. In the state legislature, A resolution was swiftly proposed to allow the University of Illinois to fire anyone for being an atheist, which would have left John Pappy McCollum unemployed at his university job. It was never passed, however. The McCollum family quickly became infamous figures in their communities and needed to try as best they could to not cause trouble and excite tensions directed towards them. Rotten fruit and vegetables were thrown at them. Their car was spit on, and an angry mob once even tried to break down their front door. Their cat was lynched by the neighborhood. One letter sent to Vashti McCollum pretty much summed up most of the town's feelings on her suit. We are in a democracy, and in a democracy, the majority rules. The majority of people believe in religious education, so why don't you shut your big mouth, you old bag? Jim McCollum especially suffered from the degradation unleashed upon him for his role in the trial by children and adults alike, to the point where he was not able to get a proper education, and at 12 years old he was taken out of Dr. Howard Elementary School and transferred to a private school in Rochester, New York. On September 10th, 1945, the McCollum trial officially opened in the Champaign County Courthouse. Vashti McCollum made the claim against the school board that the religious instruction in public schools violated the Establishment Clause of the First Amendment, which held up the principle of the separation of church and state in the country, as well as the Equal Protection Clause of the 14th Amendment, which held that state law cannot override federal law. She demanded that the Board of Education prohibit all forms of religious education in all public schools in the Champaign District. Primary arguments used in the suit included that 1. In practice, Protestant groups, Protestants making up the vast majority of the population of Champaign, Illinois, exercised dominance over minority religious denominations of Catholicism and Judaism. 2. There were thousands of different sects of Christianity practiced, as well as many other non-Christian faiths in existence, so religious classes divided into only Protestantism, Catholicism, and Judaism were not sufficiently inclusive. 3. The religious classes were only voluntary on paper, as school officials often coerced or forced student participation. And 4. The Champaign Council on Religious Education exercised great power over the Champaign School Board in its control over the selection of religious instructors, and the school superintendent had oversight over these instructors and was able to determine which religious faiths were able to participate in the instructional program. A main strategy used by John Franklin in the defense of the Champaign School Board was to try to show that, regardless of the constitutionality of the religious classes, they were not actually a major imposition to anyone and were actually a net positive for children and their parents. And Jim's problems in school were not caused by the prejudice born by highlighting his religious faith, but were instead due to the fact that he was a troublesome kid with his own set of issues. The trial, which was meant to simply be a legal procedure to determine whether or not tax-subsidized schools should be able to allocate class time for in-building religious instruction, quickly devolved into a circus where Landon Chapman and John Franklin frequently antagonized each other, turning the trial into more of a mouthpiece for the views of atheism and Christianity to come head-to-head. This was detrimental to the legal quality of the trial as a whole. Vashti became incredibly disappointed with her lawyer Chapman, who seemed to be making the trial into an opportunity to push an atheist agenda and ridicule Christian beliefs. Philip Shugg, the Unitarian minister, also provided a great scandal when he went on record on the trial as believing Jesus Christ to be no more of a historical figure than Santa Claus. Possibly the most antagonistic action of Chapman was when he decided to bring in Vashti's anti-theist father, Arthur Cromwell, against her wishes. In the trial, he made use of his anti-religious pamphlet, Rationalism versus Religious Education in Public Schools, in the proceedings. He shouted rhetoric such as, "Religious worship is a chronic disease of the imagination contracted in childhood," during the trial. This only succeeded in further tarnishing the already bad public reputation of Vashti's family, and was horrible press for the suit. John Franklin went on to conclude in his defense that the suit was nothing more than a family's attempt to get famous and spread their own disordered views on religion, and since the United States was obviously a Christian nation, The freedom of religion guaranteed by the Constitution does not necessarily apply to atheists. By the end of the trial, 49 witnesses had been called, and on January 26, 1946, the three judges, all of them extremely devout Christians, of the Circuit Court of Champaign County, assembled in the courtroom. It was ruled that Jim's problems at school were not the result of religious discrimination, and due to the fact that the classes were voluntary, the materials and teachers were privately funded, and the teachers of different faiths were allowed to teach classes, it was not found that the religious classes were unconstitutional, and the judges ended up ruling in favor of the school district's right to allow religious education time into public schools. This was a shocking decision to Vashti, who saw the classes as an obvious violation of the Establishment Clause of the Constitution, but the program was specifically crafted by the Champaign Council on Religious Education, who knew full well the unconstitutionality of trying to institute religious education into public schools, to try to present itself as legal and fair as it could be, to make sure that it would not be easy to legally dismantle. Vashti's father, Arthur Cromwell, referred to it as bootlegging religion into public schools. John Franklin was delighted by the ruling and viewed it as confirmation that the religious classes had now gained full acceptance in the public under the law, and could then expand to bring religious education to more children enrolled in public school. Illinois State Court ruling. Vashti McCollum was enraged after the loss and fired her attorney Landon Chapman for his unprofessionalism in the courtroom. Vashti was not finished with her fight, however, and desired to make an appeal to the Illinois Supreme Court after losing her suit at the district level. She sought out another lawyer that would be professional and work for cheap, and decided upon a 66-year-old former university professor living in Chicago named Walter Dodd. On November 19th, 1946, Vashti McCollum drove to the state capital of Springfield, Illinois, for the beginning of the hearing. As the oral arguments were presented, there were several state court justices who dozed off during the arguments, barely paying attention to the case at hand. None of them seemed to be at all interested in the case brought before them by Vashti, and Vashti knew that there was no hope of winning in the state court. On January 22, 1947, the Illinois State Court ended up confirming the lower court's ruling once again against Vashti McCollum's case with a unanimous decision. It can be deduced that the Illinois Supreme Court viewed the religious programs in Champaign, which were also present in some form all across the country, as entirely benign, and viewed Vashti McCollum as being overly sensitive and an insignificant minority in her gripes with the program. In reality, Vashti did have some local support from religious communities, most commonly among Jews, whose children were also sometimes the victims of schoolyard discrimination and beatings by other kids. Federal Supreme Court ruling. Vashti did not give up her fight, and she appealed her case all the way up to the U.S. Federal Supreme Court, which ended up agreeing to hear her case on June 2, 1947. Attorney John Franklin saw great stakes tied up in this final battle against religious education in public schools. In 160 years of the constitutional history of the nation, there had never been a case where the Establishment of Religion clause in the First Amendment was the subject of a judicial construction in a case directly involving it. Whatever the decision determined by the Supreme Court ruling, it had the potential to place a construction upon the amendment and set in stone a precedent for how the Establishment Clause would be interpreted from that point on. In December 8th, 1947, oral arguments were taken in the presence of the Supreme Court, with John Franklin once again representing the Champaign School Board and Walter Dodd once again representing Vashti McCollum. It would be a daunting challenge for Vashti to convince the highest court in the land that the religious classes in public schools were unconstitutional. The case opened with Walter Dodd and John Franklin being asked continuous questions by the justices about the case in far greater numbers than usual for a Supreme Court case. Walter was extremely professional and respectful towards the judges, but John Franklin often talked back to the judges and tended to get emotional in front of them. The Supreme Court justices, who were responsible for hearing cases at the national level and interpreting the Constitution in a fair and balanced way, were not as easily swayed by Franklin as the Illinois state and circuit court judges were. On the national level, as opposed to the state level, there was actually significant support from many for Vashti's appeal, who also believed that religion and public education would thrive more if they remained separate. Although Vashti, the plaintiff in the case, was a non-theist rationalist, there were many religious groups such as the American Unitarian Association, the Synagogue Council of America, the Religious Conference of Seventh-day Adventists, and the Baptist Joint Committee of Religious Liberty, who were supportive of Vashti's efforts to maintain the doctrine of the separation of church and state, and filed briefs to the Supreme Court in favor of McCollum's position on the case. John Franklin, in his defense, relied heavily in the case upon appeals to emotion and emphasized how a ruling against the Board of Education could spell disaster for religious values in the United States, which the majority of people wanted to uphold. He said it was improper that the rights of millions of parents to enroll their children in religious education at public school would be infringed merely to protect the supposedly infringed rights of one atheist mother who chose to raise her child as an atheist and thus should have to deal with the consequences of raising her child in that way. He also relied on the argument that the Constitution was a breathing document that needed to adapt, and although it might not have been the original intent of the Founding Fathers to introduce religion into public education, times had changed, and the interpretation of the Constitution had to change and conform to the times for the good of the nation. Once the court battle was finally over, both sides waited with anxiousness. On March 8, 1948, the Supreme Court finally announced its decision after what Vashti McCollum described as 3 years of headlines, headaches, and hatred. The Supreme Court had ruled 8 judges to 1 overwhelmingly in favor of McCollum's position that the religious classes on school time and school property were unconstitutional. It was the first ever recorded violation of the Establishment Clause in American history, and the first time ever that the Supreme Court had prohibited a religious activity in a public school. The use of tax-supported buildings to foster religious education and the close cooperation between school authorities and the Champaign Council on Religious Education was to be dismantled. Aftermath. For standing up for the Constitution against what she believed to be an unconstitutional breach of the wall keeping separate church and state, Vashti McCollum drew heavy criticism from many people in her town throughout the 3-year fight. She was often referred to by others by the title, "That Awful Woman," and received over 100 letters a day oftentimes, often carrying ruthless attacks on her character. Many of her previous friends stopped speaking to her, and she had many people claiming that she was a communist and an atheist militant who was intent on destroying Christianity in America. After the Supreme Court ruling, the wrath and disappointment of many editorial writers and news commentators was released, with many articles coming out criticizing the Supreme Court for endorsing communism and materialism against the wishes of the majority. Ironically enough, the most aggressive negative criticism of the ruling came from a publication from the Progressive by Milton Mayer, which contained the excerpt, "The Supreme Court has just upheld the constitutional right of Jimmy McCollum, age 12, to go to hell." However, while Vashti had many outspoken critics, there were also many who more quietly endorsed her efforts, and many of the letters she received talked admirably of her. There were also many editorial writers and news commentators that supported the Supreme Court ruling, such as a publication from Richmond, Virginia, which wrote, "If those who derive their belief from sacred writings wish to deny state sanction to atheism, as prevails in Russia, they must also deny such sanction to their beliefs." And a Jewish publication from Detroit, Michigan, which wrote, "Let's stick to the old traditions. Let's keep the state and church apart, and we'll have better chance to remain free." When the final decision of the Supreme Court was announced, many in Champaign, Illinois were disappointed, and many felt that it was a ridiculous conclusion to come away from the case with that would ultimately lead the country down a downward path where religion would become more and more divorced from people's lives. John Franklin was crushed by the decision, as were most other religious leaders, who thought that a serious blow had been dealt against religion in the United States. One minister, Reverend Higgins of the Holy Cross Church in Champaign, was quoted as saying, "I think the communists will rejoice over this court's decision." Other religious leaders were accepting of the Supreme Court's decision, however, like Reverend Albert Ackley Belaya, pastor of the First Methodist Church in Urbana, who was quoted as saying, "It may work out the best in the end. We have to find another way to teach religious education. We as churches will have to do a better job than we are, and there is certainly much room for us to do so." I was not surprised by the decision, and there is certainly nothing we can do to alter it. The churches must work harder. Vashti McCollum was overjoyed when she heard the decision, and was glad her efforts over the past 3 years had not been for nothing. Her sons, husband, and father were also greatly pleased with the decision, and were incredibly proud of Vashti. Vashti's life somewhat returned to normal after the decision, though she had succeeded, inadvertently, in becoming a minor celebrity, and she was invited to give frequent talks at civil liberties meetings throughout the country. 3 years after her victory in the case, Vashti published a book called One Woman's Fight, which shared her personal story of the events that took place within the frameworks of the case that received favorable critiques. Significance. Before the McCollum case was brought to the Supreme Court heard an earlier case, similar to the McCollum case, known as the Everson bus case, regarding a man in New Jersey who sued his local school district to stop it from using tax-subsidized buses to transport students to religious schools. Despite the court ruling in the case that the Establishment Clause of the Constitution applied to both the federal and state level, and that the Founding Fathers intended to build a wall of separation between church and state, the court still ruled in 1947 5-4 against Everson, and held that using taxpayer dollars to fund buses that brought children to religious schools was legal. This could have set a precedent for the interpretation of the Establishment Clause, but in the end, the split decision only led to confusion. The McCollum v. Board of Education case served to clear up some of the confusion on what the judges truly meant when they talked about Thomas Jefferson's ideal of a strict wall of separation between church and state. The Illinois Champaign school system was not the only school system in the country to allow religious education to be held in public classrooms. Approximately 2,000 communities throughout the nation offered similar release time programs to those instituted in Champaign, which were attended by nearly 1.5 million students in total. The Supreme Court used the landmark separation of church and state case McCollum v. Board of Education as a reference case to determine the constitutionality of any other release time program instituted throughout the country, and many districts on the national level began dropping their religion classes in public schools as a result. The court concluded that no state can utilize its public school system to aid any religious faith or all religious faiths in the spreading of their morals and doctrines, which was the truly neutral position to be taken if religion and government were to best flourish separate from one another in their respective spheres of public life. This Supreme Court case initiated a multitude of later Supreme Court decisions that would greatly decrease religion's presence in the public education system over the years. What made the McCollum v. Board of Education case different from the Everson bus case was that the religion classes were being held on public school property during regular school hours. Students were still allowed to be dismissed early from class to attend a religious service in a privately owned building, which was confirmed by 6 judges to 3 as constitutional in the 1952 Supreme Court case Zorak v. Clausen, and could be transported in a tax-subsidized vehicle, but no religious instruction or worship was to be supported by publicly funded institutions of learning. In the years following the McCollum case, there were several lawsuits that were filed in different parts of the country that further expanded on the McCollum ruling of the mixing of religion and public schools being unconstitutional. such as Engel v. Vitale in 1962, which proclaimed that it was unconstitutional for state officials to create an official state prayer for a recitation in public schools, Abington v. Schempp in 1963, which determined that Bible readings in public schools were unconstitutional, and Lee v. Wiseman in 1992, which held that public schools were not able to sponsor clerics to conduct non-denominational prayers. Reflection. Although many people try to claim that the United States of America is and was founded as a Christian nation, it has only ever been Christian majority and was actually the first ever secular nation that didn't have an official state religion or state church. Many of the nation's founding fathers were highly influenced by Enlightenment rather than religious ideals, and they were keenly aware of the downsides of trying to mix religion with government, and there are many quotes from them that make this fact evident. The Treaty of Tripoli, written by Washington and signed by James Madison in 1796, is quoted in it as saying, "The government of the United States is not in any sense founded on the Christian religion." "In God we trust" was not the original motto of the United States, but was instead "E pluribus unum," out of many one. However, there were many religious revivals that took place in the nation over the course of its history, particularly after times of great strife and uncertainty, like the Civil War and World War II, that sought to have Christianity play a much more important role in public life, and it was assumed by many that religion and spirituality could provide the only beneficial system of morality in the nation. The McCollum v. Board of Education case, however, set the precedent that even in a highly Christian nation like the 1940s and 1950s era United States, religious education was simply a private directive of the church and parents, and not to be intermingled with government or public education. In the McCollum v. Board of Education case, John Franklin and many others feared that the Supreme Court ruling would spell the beginning of the decline for Christianity in the nation, and although it is difficult to claim that there is a correlation, since the 1950s, the rate of church attendance for Americans has drastically declined, while non-religious people now make up approximately 25% of the U.S. population. Religion clearly has much less of an impact on regular public life for many Americans, especially young Americans, now than it used to, and a decision like the McCollum v. Board of Education case is simply not looked at by people with the same scandal as it was when it was first decided. However, there are still many Christians in the nation who believe that the decline of religious fervor in the nation has led to many of the problems, real or perceived, that are facing the nation today. The 1980s conservative era, brought about by President Ronald Reagan, saw a greater emphasis being put on Christian values in the public sphere, and today the Republican Party is often called the party of the Christian evangelicals, making many attempts to give religion a much greater role in government and politics. Current Secretary of Education, appointed by President Donald Trump, Betsy DeVos, has outright stated her support for education reform that can advance God's kingdom. With the confirmation of conservative Christian Justice Amy Coney Barrett to the Supreme Court, and the confirmation of several other conservative Christian members and Jewish members to the Supreme Court in the past, it is possible that precedent regarding the doctrine of the separation of church and state could be overturned to allow a greater mixture of religion and government in the future. So in reality, Vashti's fight against the introduction of religion into public education is still being fought today. To end this presentation, I think it would be proper to end on a perceptive quote by John Franklin in an interview a full 30 years after the Supreme Court decision. "I think that the line is not drawn as sharply as it appeared to be by the decision. Change is jerky, not smooth. The public and the court have realized that there is to be some necessary cooperation between the church and state. The pendulum has swung back to the middle. Whether or not you agree with Franklin's perspective is up to you, but one must agree, his quote has been awfully prophetic." Works cited. Sources for the research purposes are linked in the description of the video below.